Manhattan prenuptial agreement. Lawyer planning a life together means more than romance and requires clarity about how marriage will affect your finances. Under New York Domestic Relations Law Section 236(b), you can sign a prenuptial agreement before marriage to set rules for dividing property, handling debts, and determining spousal support rather than relying on default equitable distribution laws that apply when couples divorce. Without a prenuptial agreement, the courts consider assets acquired during the marriage using marital funds as marital property subject to division, while property owned before marriage or received as a gift or inheritance remains separate. A prenuptial agreement can specify which assets stay separate and which become marital property, protecting appreciation on separately owned real estate, businesses, and investment accounts even if marital funds contribute to mortgage payments or improvements. The agreement may state that a business or professional practice remains separate property and establish a method for valuing any marital interest so that one spouse does not have to sell assets or give up control during divorce. You can also use it to set the amount and duration of spousal maintenance or waive maintenance entirely, although courts will not enforce waivers that leave a spouse without adequate means of support. The contract can assign responsibility for debts each spouse brings into the marriage, ensuring you are not held liable for student loans, credit card debt, or other obligations your spouse accumulated before you wed. Importantly, New York law prohibits prenuptial agreements from addressing child custody, visitation, or child support, as courts decide these matters based on the child's best interests at the time of divorce. Certain situations make these agreements particularly valuable, such as second marriages with children from prior relationships, significant asset disparities between partners, business ownership, anticipated inheritances, and when one spouse plans to earn an advanced degree during the marriage. For example, if you own a business, the agreement can prevent your spouse from claiming an interest in the business value accumulated during the marriage and preserve continuity by establishing a buyout process. If you expect to inherit family wealth or real estate, a prenuptial agreement ensures those assets remain separate property and are protected from division even if you commingle them with marital funds later. When one partner has substantially more assets than the other, the agreement can provide clarity and fairness by protecting premarital assets while still providing for the less wealthy spouse. To be enforceable, you must make full financial disclosure of all assets, debts, and income, because hiding assets or understating their value gives your spouse grounds to challenge the agreement. The agreement must be in writing, signed by both parties, and acknowledged or notarized like a deed. Oral agreements or unsigned documents have no legal effect. Each party should have their own attorney because sharing one attorney creates a conflict of interest and may allow challenges if one party later claims they did not understand. Courts will not enforce unconscionable agreements that waive all rights and leave a spouse destitute, and also examine whether negotiations were fair and free from duress or coercion. Presenting the agreement just days before the wedding or using threats to obtain a signature are common red flags that suggest duress and can make a court refuse enforcement. For a fair process, start discussions months before the wedding, hire separate attorneys, gather financial documents, and negotiate as partners seeking mutual protection rather than adversaries competing to win. Consider how the terms will work if you raise children, your business value changes, or you stay married for decades, because provisions that seem fair now may become unconscionable if circumstances change. Life circumstances change and you can modify a prenuptial agreement through a postnuptial agreement after marriage. Both spouses must consent in writing, and the document must be notarized with full disclosure and fairness. Manhattan divorce courts enforce prenuptial agreements if they were properly executed with adequate time, separate counsel, full disclosure, and reasonable terms, but may invalidate agreements that are unconscionable or where circumstances have changed dramatically. Common questions involve drafting prenups without lawyers, protecting inheritances, cost, refusal to sign, and whether having a prenup signals an expectation of divorce. The article explains that self-drafted agreements are risky, inheritances need extra protection, costs depend on complexity and separate attorneys, you cannot force a partner to sign, and a prenup is like insurance. Negotiating a prenuptial agreement can actually strengthen your relationship by forcing important conversations about money, values, and expectations before marriage. This law firm emphasizes that a lawyer can guide you through creating a fair agreement that protects your assets without damaging the trust and partnership you are building with your future spouse. The attorney at the law office of Richard Roman Shum helps Manhattan couples understand what provisions make sense and ensures agreements comply with New York law. If your circumstances change or you need to enforce or challenge a prenuptial agreement, the law firm provides guidance and representation in Manhattan courts. For personalized assistance, contact the law office of Richard Roman Shum, Esq., and speak with a dedicated lawyer about your prenuptial agreement. The firm's attorney serves clients with professionalism and care, helping them achieve peaceful resolutions to complex legal issues. Law office of Richard Roman Shum, Esq. is located at 20 Clinton Street, FRNT 5D, New York, New York, 10002, United States, and can be reached 646-259-3416.